Okay, we're talking about attorneys today, members of the bar. This is third in the series, um, and so let's get going. Some foundational videos that would be a good idea to watch would be Bar Members 1, Bar Members 2, Martial Law is Here, Color of Law, Void Judgments, and my most recent one, State Statutes are Federal. All state statutes are federal. Um, and I like to start off by talking about prostitutes. Prostitutes is a terminology that I first heard from Paul Craig Roberts, a former Assistant Secretary of the Treasury during the Reagan administration. You'll never hear this information from any of the prostitutes. Now, that's alternative media. That prostitutes does not include the alternative media, of course. Prostitutes is basically the news media that's bought and paid for by the New World Order, and so they are trumpeting the lies and the disinformation. And if you think about it, they're Satanists. And so this is some scriptures. John 8:44 says, "You're of your father the devil, and the lust of your father you will do. He was a murderer from the beginning, and abode not in the truth, because there is no truth in him. When he speaketh a lie, he speaketh of his own, for he is a liar and the father of it." Okay, so that's the prostitutes. Okay, gee, that sounds like a lot of other people I know. Anyways, and then in Revelations 21:8, but the fearful and unbelieving and abominable and murderers and whoremongers and sorcerers, well, sorcerers are the pharmaceutical drug pushers, and idolaters and all liars shall have their part in the lake which burneth with fire and brimstone, which is the second death. And that's Revelations 21:8. So now I would like to say here that Obama is a Satanist, and so and then how do you know he's a Satanist? Well, because he lies. Okay, I mean, how do you know he's lying? Well, his lips are moving. That was the same thing with Clinton. You know, when I used to, I don't get much TV these days because there's just nothing on there that I want to watch. But whenever I see Obama or whenever I see Clinton, or it was whenever I saw Clinton, I would just surf right on past because I'm not going to sit there and get lied to. And so that's how you can tell that when Obama's lying, his lips are moving. This is really, you think about it, it's the hallmark of the Democratic Party. They're all Satanists. They cannot tell the truth. Okay, they're liars. They come out with terminologies like politically correct, which is another way of saying that you're telling a lie. They call their lies spin. How are you going to spin it today? Well, it's how are we going to tell our lies today? Of course, the Republicans aren't much better, but they're a little better, but not much. So anyways, now to the bar members. And so to start that off, we talk about the inns of court. These are certain private unincorporated associations in the nature of collegiate houses located in London and invested with the exclusive privilege of calling men to the bar. And that's taken from Black's Law Dictionary, 5th edition. That they're unincorporated, think about it, they're trusts. There's an American Inns of Court. Okay, this is their website. They're located in the Alexandria, Virginia, and there's also local inns all over the place. And we're going to talk about some of those local inns. In the previous bar members videos, we talked about the Inns of Court. It's domiciled in the city of London. It's a private unincorporated organization. And then we also talked about the American Inns of Court. And that's all we're going to talk about today, or at least briefly touch on it. This is actually a Google search page that I did for Inns of Court. And it talks about the American Inns of Court. There's even a Wikipedia page. And then it also talked about this Eldon v. Mann Inn of Court in Fort Worth, Texas. Seemed to come up there because I guess that's maybe nearest where I'm at. This is taken from Encyclopedia Britannica, their website, and it talks about the Inns of Court. It says in London, the group of 4 institutions of considerable antiquity that have historically been responsible for legal education. Their respective governing bodies, the benchers, exercise the exclusive right of admitting persons to practice by a formal call to the bar. They consist of the Inner Temple, the Middle Temple, both housed within the area known as the Temple. Lincoln's Inn, Gray's Inn, all of which are located in the general vicinity of the Royal Courts of Justice, if you can call them that. At the boundary between the city of London and Westminster. Okay, so remember I was talking about there's an area of London called the City of London. that's about 2 square miles in downtown London. And so this is what they're talking about there at the boundary between the City of London and Westminster. The Inns of Court are voluntary societies, unchartered and unincorporated, which means they're a trust. Hence, the early history is obscure. Since their inception in the Middle Ages, however, they have been devoted to the technical study of English law rather than Roman law, which was taught in the universities. And it goes on to say, in the 14th century, many of the household clerks, clergy with at least minor orders, of the chancellor's office formed inns and appear to have taken students for training. Okay, chancellor's office, chancellor is a court of equity. Okay, by the end of the century, these inns were in danger of being submerged by a flood of attorneys-to-be and students who used an inn of chancery as a preparation for entering an inn of court. Okay, so this is all about equity, actually. Eventually, each inn of court secured control of one or more inns of chancery and supervised its affairs, appointed readers to teach in it, and later often bought its premises, becoming its landlord. And then it goes on to say by the 15th century. So the 14th century, as you think about it, is the 1300s. 15th century is the 1400s. And it goes on and talks about it. If you go down to the bottom, it says, because the law was highly technical, proficiency could be acquired only by following the demanding studies of the inns. In practice, the inns thus had a monopoly over legal education. In the 15th and 16th centuries, however, many students joined the inns for the purpose of getting a general education rather than legal training. By the end of the 16th century, the Inns of Court had begun to exclude attorneys and solicitors and refused to call them to the bar, with the result that attorneys especially fell back on the Inns of Chancery, okay, and finally came to form a profession distinct from that of the barristers, okay. So those are, excuse me, chanceries, equity. They're talking about solicitors there. So then you go up to the top. It says, previously law was learned in the course of service, the first rudiments possibly in private clerkship to some official. By the mid-13th century, when the common law had become extensive and intricate, there arose a class of men, literate but lay, who created and dominated the legal profession and set up the Inns of Court as an answer to the problem of legal education. Manuals and books were produced in French rather than Latin. The students listened to arguments in court and discussed law among themselves. Okay, now think about that. So it's courts of chancery. They're talking about courts of chancery here, and they're talking about French. Okay, so this is all civil law. This is equity. Anyways, and then you go down to the highlighted part. Oh, we already read that. So now let's talk about the Bar Council. And so the Inns of Court and the Bar Council are two different things. Okay, so anyone wishing to join the bar must join one of the inns, which are responsible for calling barristers to the bar. The inns also have a role in administering disciplinary tribunals to deal with more serious complaints against barristers. Okay, so there's barristers and there's solicitors. A barrister is someone who actually goes to the bar, which is in the courtroom. It's a bar handrail basically that goes across the room and where you make your arguments. Anyways, so then the four inns, okay, the Inns of Court, the four of them, there's Lincoln's Inn, there's Inner Temple, there's Middle Temple, and there's Gray's Inn. And so this is all tied in with Chancery and Masonic, okay, it's very Masonic. Look at this Honorable Society of Lincoln's Inn, okay, that's about as Masonic a phrase as you can get. Anyways, the medieval hall and gateway abutting into Chancery Lane. Oh, and here's a close-up picture, right? And here's of all that stuff I just read in close-up. And here's the big picture, and then we'll go in closer. Honorable Society of Inner Temple. So the Inner Temple occupies the eastern half of a site known as the Temple, which was chosen by the Crusading Knights Templar. Gee, that sounds like Masonic. The round church, which they constructed there, modeled on the Church of St. Sepulchre in Jerusalem, still forms part of the Temple Church. By the mid-14th century, when the royal courts became permanently sited in Westminster, the temple had become a home for lawyers who formed two societies there, the Inner and Middle Temple. each occupying one of the halls constructed by the Templars on the site. The status was formally recognized in 1608. And so, again, the Honorable Society of Inner Temple, the Honorable Society of Middle Temple, and then the Honorable Society of Gray's Inn. Okay, so these are the four that they're talking about. And then at Google, I did a search for American Bar Association, and so the Inns of Court and American Bar Association are two separate entities. The American Bar Association was set up in 1878, which is about 17 years after Congress or the Southern states walked out of Congress. The bar is separate from the Inns of Court. American Bar Association was set up in 1878 after they facilitated the disappearance of the true Article 13 Amendment. Just very interesting. And this is the true Article 13 Amendment. And it says, if any citizen of the United States shall accept, receive, claim, or retain any title of nobility or honor, okay, and so when they join the bar, okay, that's all coming from England. Okay, so they're receiving a title of nobility or honor. They're receiving an honor from a foreign power. Okay, and so technically all bar members are not U.S. citizens under the true Article 13 Amendment. They had to make that thing disappear. And this is about Masonic. Okay, honorable. This is the title formally given to a degree of the fellowcraft. Okay, so you got to think about it now when you get these liars. I meant lawyers. No, actually, they're liars. Get up in court and they call the judge honorable. They're basically speaking code words to him and telling him, "Hey, we're one of your buddies here, so let's screw this other guy." Exactly what they're doing. That's taken from an Encyclopedia of Freemasonry. And a title, distinctions by which persons are known. The Constitution of the United States forbids the tyrant by the United States or any state of any title of nobility. Judges and members of Congress get a title called honorable, and members of the bar and justices of the peace are called esquires. That's Bouvier's Law Dictionary, 1856 edition. And this is actually taken from the Masonic Handbook, page 183. It says there, whenever you see any of our signs made by a brother Mason, especially the grand hailing sign of distress, you must always be sure to obey them, even at the risk of your life. If you're on a jury and the defendant is a Mason and makes the grand hailing sign, you must obey it. You must disagree with your brother jurors if necessary, but you must be sure not to bring the Mason guilty, for that would be disgrace upon our order. You must conceal all crimes of your brother Mason except murder and treason, and these at your own option. Okay, so in other words, you can get him off of murder and treason too. And you should be summoned as a witness against a brother Mason. Be always sure to shield him. Prevaricate, don't tell the truth. In this case, keep his secrets. Forget the important points. It may be perjury to do this true, but you're keeping your obligation. Okay. And this is Encyclopedia of Freemasonry, 1966 edition, volume 2, page 555, 556. Perjury. In municipal law, perjury is defined by the willful false swearing to a material matter when an oath has been administered by lawful authority. The violation of vows or promissory oaths taken before one who is not legally authorized to administer them, that is to say, one who is not a magistrate, does not involve the crime of perjury. Such is the technical definition of the law, but the moral sense of mankind does not assent to such doctrine and considers perjury as the root of the word indicates. And doing of that which one has sworn not to do, or omitting to do that which one has sworn to do. The old Romans, and it goes on, the old Romans seem to have taken a sensible view of the crime of perjury. Among them, oaths were not often administered, and in general, a promise made under oath had no more binding power in a court of justice than it would have had without the oath. In other words, you can perjure yourself all day, who cares? False swearing was with them a matter of conscience, and the person who was guilty of it was responsible to their deity alone. Okay? So they could lie and steal and cheat all they wanted. See, they were Satanists. If you think about it, that's exactly what they are. They were Satanists. Okay? That's exactly what it is. And we'll go into that further. The state Supreme Court regulates bar members who operate in federal areas of Texas, and this is the same in any other state. They're all the same. But this is the Texas Government Code, section 82.004. It says the Board of Law Examiners, acting under instructions of the Supreme Court, as provided by this chapter, shall determine the eligibility of candidates for examination for a license to practice law in the state. The Supreme Court regulates everything in the state. And so, if you think about it, it's all a corporation. Well, we're going to go into that. In America, the bar is private. The bar disciplines attorneys. The bar disciplines judges. The bar operates only in federal areas. Okay? And that's what you have to understand. It's only in federal areas. This is the American Inns of Court Foundation, the Eldon B. Mahan American Inn of Court in Fort Worth. So let's get in a little closer. And this is actually the historical part. The records of Lincoln's Inn go back to 1422, almost 80 years earlier than any of the other inns. The records of Middle Temple and Inner Temple date to 1501 and 1505, respectively, and the records of Gray's Inn go back to 1569. We do not know precisely when lawyers and students of the law first began to occupy the buildings of these various estates. We do know that as late as the 13th century, the study of law remained under clerical control. A number of events that gave rise to the growth of a colony for the housing and education of lawyers in the village of Holborn. These events included the issuance of a papal bull forbidding the clergy in England from teaching the common law, and the enforcement of a certain clause in the Magna Carta leading to the establishment of the Court of Common Pleas in Westminster Hall. And so the Pope didn't want anybody talking about common law, obviously. Didn't like the common law, didn't want people having rights like they're slaves. That's exactly what that's all about. And it goes on, it says the membership of the inns now consists of students, barristers, and benchers. Call to the bar is made by the treasurer, after which a student becomes a barrister. It's interesting, made by the treasurer. The highest rank is that of the master of the bench or bencher, right? That's judge. Okay, those are judges. Judges are called benchers. Benchers constitute the governing entity of the inn. Benchers periodically meet as a body in the Inner Temple and Middle Temple. These meetings are called parliaments. Isn't that interesting? While Lincoln's Inn refers to the meetings as councils and Gray's Inn designates them as pensions, each inn has a number of officers, treasurer being the chief among them, okay, the guy in charge of the money. Notable members, you go down to the bottom, it says notable members of Lincoln's Inn include Sir Thomas More, Lord Ellesmere, Sir Matthew Hale, William Penn, okay, and that's interesting. I don't know how many of you know this, but William Penn is the guy that got granted Pennsylvania by the King of England, okay. William Pitt, President Dwight Eisenhower, and Dean Acheson, okay, were members of Lincoln's Inn. And it goes on. Notable Middle Templars include Charles Dickens, Sir Francis Drake, Sir Walter Raleigh, Edmund Burke, Sir William Blackstone. Okay, Blackstone was was a Middle Templar. Additionally, we find the following Middle Templars among the signatories to the American Declaration of Independence: John Dickinson, Edward Rutledge, Thomas Hayward Jr., Thomas Lynch Jr., Thomas M. Keene, Arthur Middleton, William Howard Taft, who served both as President of the United States and as Chief Justice of the Supreme Court, was also a Middle Templar. And notable members of Gray's Inn, Sir Winston Churchill, Franklin D. Roosevelt was a member of Gray's Inn. So you're seeing some things going on here. I don't know about you, but I'm seeing them. All of this stuff is basically it's all satanic, and this is all how they kept control of the United States. This is exactly what's going on. Overview of the American Inns of Court. That's all taken off the Fort Worth Inns of Court website. And we're still on there, quite frankly. American Inns of Court are patterned after the English Inns of Court. American Inns of Court is the fastest growing legal organization in the country. Today, there are more than 3,300 American Inns of Court in 49 states and the District of Columbia. New inns are being organized continually. More than 20,000 judges, lawyers, law professions, law students are currently members of an American Inn of Court, including 40% of all federal judges and over 1,500 state judges. And it talks a little bit about the beginning. And it says Chief Justice Berger, former Solicitor General Rex Lee, and Senior United States District Judge A. Sherman Christensen founded the first American Inn of Court in 1980. The inn was affiliated with the J. Reuben Clark Law School at Brigham Young University in Provo, Utah. And so it was Mormons that set it up originally. Okay. And there's Satanists have infiltrated the Mormon church. Not all Mormons are Satanists, but there's certainly in the leaders, there's some Satanists in there for sure. And so Satanists started this Inns of Court. Anyways, for what that's worth. Chief Justice Berger, former Solicitor General. Oh, we got that already. It goes on to say, it says to foster some of the objectives of each inn as to foster greater understanding and appreciation of the adversary system of dispute resolution in American law. In other words, the judge gets to sit up there and play stupid, okay? And if you don't know the law or you don't do something at the right time, he pretends he didn't do it, okay? I mean, it's so full of fraud, it's unbelievable. And I point that out all the time, okay? Anyways, to provide significant educational experience which will improve and enhance the abilities of lawyers and counselors and advocates and the abilities of judges as adjudicators and judicial administrators. Okay, so there's no judges, they're all clerks masquerading as judges. That's exactly what that's saying there, okay? Abilities of judges as an adjudicator. An adjudicator is a clerk masquerading as a judge, and a judicial administrator is a clerk masquerading as a judge. That's right. The adversarial system of justice is satanic. The judge is a clerk masquerading as a judge. He's sitting there playing stupid. They literally create millions of codes, rules, and regulations so they can always railroad you or let you go, depending on what their agenda is at the time. If they feel like railroading you, then you get railroaded. And it doesn't matter what you say or do. If they feel like letting you go, then you get let go, and it doesn't matter what you say or do. They create rules. There's hundreds of pages long to make sure that their bar members always have the advantage. They sell their justice, okay, and that's just us, by the way, not justice. Inns of Court. When browsing around the various Inns of Court website in England, I found a link to the Scotland Faculty of Advocates. Okay, and this is really good. Scotland Faculty of Advocates. Okay, and this is actually, I got 4 documents off of there, and this is the first one that we'll go through. It's called the Faculty of Advocates, and if you look at the highlighted part, it says that therefore it offers annual scholarships for the purpose which is to offer assistance to entrants who intend to practice at the Scottish Bar. And then another document that I got was becoming an advocate. Okay, and it's talk about, you look at the top there, let's get in close. The process of becoming an advocate in Scotland is governed by the Faculty of Advocates. Regulations as to entrance. The process outlined below is for barristers from England and Wales, Northern Ireland, and legal practitioners from other member states of the European community. And so this is not unique to Scotland, okay? This is basically all over Europe, okay? Anyways, let's keep going here. And this is the second page. This is actually, it talks about, it's the Dean Secretariat, Faculty of Advocates, Parliament House, Edinburgh, Scotland, okay? So this is like, the government, basically. And now frequently asked questions, okay? Let's look at some of these frequently asked questions, okay? What's the difference between an advocate and a solicitor? Well, this is kind of interesting. An advocate is who work independently of each other, and they're the guys that go to the bar. Solicitors work in an office, and they don't usually go to the bar, basically, as a general rule. Can I become an advocate straight after obtaining my degree, or is there training involved? In order to become an advocate, you must obtain the relevant standard of law degree, the diploma in legal practice, and complete a period of at least 21 months training within a solicitor's office, although the faculty recommends that you complete a full 24 months traineeship. Okay? And so they have a name for the traineeship. And we're going to go through this here in a second. It's kind of like an apprenticeship program. What are the timescales involved in order to commence deviling pupillage? Okay, and you're reading that right. Deviling, okay, they got the deviling spelt wrong, I think. But in order to commence deviling in October of any year, the applicant must be matriculated entrant by 31st December of the previous year, okay? Deviling, okay? That's what they call it. It's deviling, okay? And these guys, I mean, you're going to tell me they're not satanic? Hello? Scotland Faculty of Advocates, step-by-step guide, okay? Becoming an advocate. The process of becoming an advocate in Scotland is governed by the Faculty of Advocates Regulations as entrance. The faculty has one intakes of devils each year, okay? Yes, if you're learning how to become an advocate, okay, as a member of the bar, then you are a devil, okay? Yes, that's right. Okay, you're reading that right. And now go down to the bottom. It says complete all training requirements as requirement of the faculty. Deviling, called deviling. A devil must complete training required throughout deviling, commencing in October through the following June or July. An assessment must be completed, and a devil must be signed off by their devil master. Okay, you get a devil master too, as having successfully completed their deviling prior to their admission in June or July. And this is the next page. And this is the highlighted part. Please look at the link on the right side of this page where information on the deviling process can be found. And it's admission of an advocate. And it's talking about the Dean's Secretariat, Faculty of Advocates, Parliament House, Scotland, Edinburgh. Okay, and then the Devil's Handbook. Yes, they have a Devil's Handbook too. Look at this, a Devil's Handbook. The Devil's Handbook talks about selecting your devil master, duties of devils, duties of devil masters. It's 111 pages long, and once admitted as an advocate, you can practice in other European countries. See, here's the next page. This is the table of contents for the Devil's Handbook. Framework of deviling, the regulatory framework of deviling. Devil Masters 1.3, 1.4, selection of a devil master, 1.5, registration of deviling. 1.7, scheme of assessment, scheme for assessment of devils. Section 2, the duties of devils. 2.1.4, interim devil masters report. 2.1.5, devil masters reports. The duties of devil masters. What to expect while deviling. You and your devil master. Oh, okay, here's the big picture, a little bit closer. Appendix. Oh, and this is the appendix, okay? So that's after all of that. Devil Master's general obligations and functions. Monitoring progress during deviling and obtaining feedback. Devil's checklist. Devil Master's reports, okay? Okay, so, and then the introduction. Says deviling is the final step to qualifying to become a practicing advocate. During this period, you will undertake practical training supervised by an experienced member of the Faculty of Advocates. You will devil to a devil master. On satisfactory completion of deviling and compulsory education courses, you will be entitled to seek admission to the public office of advocate. The purpose of this handbook is to provide guidance, promote good practice, and achieve greater consistency in deviling experiences by providing a central source of information and advice to those commencing this process. Okay, so this is all well done here, okay? Revelation 17, 1-2, I will show unto you the judgment of the great whore that sitteth upon many waters, with whom the kings of the earth have committed fornication. Inhabitants of the earth have been made drunk with the wine of her fornication. Well, penance. This is Jacob A. New Law Dictionary, 1750 edition. The penance is a punishment imposed by crime for a crime by ecclesiastical laws. It is an acknowledgement of an offense. Penance may be changed into a sum of money. In other words, you can buy off the Vatican, okay? They can be bought off, okay? And of course, this money is used for pious uses, okay? It's called commuting. Has anybody ever had a sentence commuted? Penance, an ecclesiastical punishment which affects the body of the penitent, to which he is obliged to give public satisfaction to the church for the scandal he hath given by his evil example. Oh, what a scandal! Penance may be changed into the sum of money to be applied to pious uses. Of course, it's always used for pious uses. And this is called commuting, okay? It's called commuting, and that's taken from Coke, okay, Book 3, Institutes of the Laws of England, page 150, and Book 4, Institutes of the Laws of England, page 336. And that's taken from Tomlin's Law Dictionary, volume 2, okay? And penitentiary, okay? Penitentiary is a prison or place of punishment, any place designed for the confinement of convicts, okay? And this is in the footnotes. This is Anderson's Law Dictionary, 1889 edition. And this is in the footnotes. A penitentiary has meant a penitent, an ordainer of penances, a place for penitents, okay? And then it says, see locus penitentiae, okay? And so we're going to go there in a minute, but about it, boys and girls. A penitentiary is called that because that's where you have a chance to think about your sins and and maybe change your way of life. Okay, the Vatican has given you a chance, the next 30 years to think about your sins and maybe want to change your way of life. And over that speeding ticket, or over that that going through a red light, or something like that. That's not a breach of the peace. Okay, these are all ecclesiastical breaches. Okay, uh, penitentia, okay, is repentance, altered intent. Locus penitentia. This is Valentine's Law Dictionary. Altered intent. So you got to repent. So they're going to shove their ecclesiastical law down your throat so that you can repent. Locus penitentia, a place or an opportunity to reflect or repent. Okay. So they're going to shove their ecclesiastical law down your throat so you can repent. And this is all taken from Ballantyne's Law Dictionary in various places. Penitentiary, a prison for the confinement of persona convicted of a crime, a state prison. Any kind of prison is penitentiary, and that's where you get to go to reflect. Okay, you get to reflect, and they hold you there, and so that you can reflect on your sins. Oblations, okay, now get a load of this. Jacobin New Law Dictionary, and actually this was consistent over a lot of these older law dictionaries, but this is found in the canon law, okay. And then oblations penitentium, which were given by persons penitent. Okay, so you can buy off the priest. Okay, there you go. This is what this is all about: is buying off the priest, and so that you don't get sold into slavery. It's all a commercial transaction. That's exactly what it is. Okay, and so if you go back here, I will show unto the judgment of the great whore that sitteth upon any many waters. Okay, that's the Vatican, boys and girls. The great whore, they can be bought off. They sell themselves for money. They do it every day. What do you think? Anybody that goes into jail is in jail because they got sold there, and the Vatican winds up with the money. And with whom the kings of the earth have committed fornication. Well, fornication's an illicit activity. And the inhabitants of the earth have been made drunk with the wine of her fornication. Well, think about it, boys and girls. Fake money that circulates around, and how everybody's getting rich. The stock market's going crazy. The price of my house, you can't lose on the stock market. I've had people tell me that. So the inhabitants of the earth have been made drunk with the fake money that's circulating around, and the Vatican is selling it, okay, because it's all got interest, and they're selling the right to get the interest, okay. That's exactly what they're doing. And kings of the earth have done it, okay. They committed fornication, an illicit activity. Anyways, so let's keep going here. This is 2 Peter 2 and 3. And through covetous shall they with feigned words make merchandise of you, okay, whose judgment now of long time lingereth not, and damnation slumbereth not. And that's exactly what they did. When they sold you into slavery, they make merchandise of you, and that's everybody in jail is exactly what they did. If a man be found stealing any of his brethren of the children of Israel, make merchandise of him, or selleth him, then that thief shall die, and thou shalt put evil away from among you. So that's Deuteronomy 24:7. So, boys and girls, if we want to avoid the judgments of God, then we are going to have to put these people to death. Okay, that's really what it comes down to, is they need to be put to death. Okay, we need to put this evil away from among us. Okay, everybody that was sold into slavery, which is everybody that's in jail. Okay, we need to put a stop to this. Okay, now I don't want to say that we should do any vigilantism. Of course not. Again, we have to follow the law. But that means common law courts and bringing these criminals to justice. Okay, but that's what we need to do. Yep. Anyways, let's keep moving here. I know the blasphemy of them that say they are Jews or Christians, etc., and are not, but are the synagogue of Satan. Okay, and they are Satanists. And that's Revelations 2 and 9. And we're going to go into how they're Satanists here in a little while. Okay, this is the Judicial Code of 1911. This is Chapter 231, approved March 3rd, 1911, found at 36 Stat 1087. It says, being enacted by the Senate and House of Representatives, that the laws relating to judiciary are hereby codified, revised, and amended. Okay, so that's when what they did is that's the first time they made a judicial code. And then it says, Section 9, the district courts, as courts of admiralty and courts of equity, shall be deemed always open for filing of any pleading. Okay, so remember, so what they're saying is U.S. district courts are courts of admiralty and courts of equity. Okay, that's it. Okay, that's why they have that gold fringe flag in there, because it's all commerce, it's all business. The Judicial Code of 1911, the oldest statute repealed, is 1875. When 28 U.S.C. was enacted as positive law, the oldest statute repealed was 1863. I think that was done in 1945, 1940, maybe 1940. So it was 1911 when the Judicial Code was done. 28 U.S.C. was enacted, I think, in 1940. 28 U.S.C. is for the District of Columbia and the Territories. Okay, that's all of the stuff in there is for the District of Columbia and the Territories. And we're going to go through that right now. As a matter of fact, it was 1948 at 62 Stat 869 when the Title 28 United States Code was created, was enacted. The Schedule of Acts repealed shows the oldest repealed statute was in 1863. The originating document is for the Court of Appeals. Okay, 28 U.S.C. Section 41. The originating document was for the Court of Appeals, found at 31 Stat 85, which is an appropriations bill. They do that all the time. Okay. So Chapter 191, and enacted temporarily provide revenues and civic government for the government of Puerto Rico and for other purposes. And that's April 12th, 1900, at 31 Stat 77. And it said the provisions of this act shall apply to the island of Puerto Rico and to the adjacent islands. Originating document. So it's Section 33 of that act. It says, under and by virtue of the General Orders number 118 and promulgated by Brigadier General Davis, United States Volunteers. Okay, so this is all martial law. This is under martial law under military courts. Okay, that's exactly what it is. Judicial power shall be vested in the courts and tribunals of Puerto Rico is already established, and now in operation, including municipal courts under and by the General Orders. Okay, so it's all under martial law. And then it goes on at Section 34, which is the next section. The United States District Court, and this is the first time they use that terminology, okay, because before then it was always District Court of the United States, okay? But so they converted it over. The United States District Court, hereby established, shall be a successor to this provisional court, again under martial law, okay, because that's what they're talking about. General Orders number 88, promulgated by Brigadier General Davis, the United States Volunteers, etc., etc. All courts of appeals are territorial. District courts are both territorial and de jure. Appropriations Bill at 31 Stat 85 is where United States District Court is mentioned for the first time. Okay, and we're going to go into that, but there's even a court case that talks about it. The United States District Court is not a true United States court established under Article 3 to administer the judicial power of the United States, created by virtue of the sovereign congressional authority granted under Article 4, Section 3 of making all needful rules and regulations respecting territory belong to the United States. Okay, so it's a territorial court. Okay, and all the courts nowadays are territorial, but they don't have to be. You gotta invoke the de jure court. So the filing fees. This is 28 U.S.C. Section 1914, and it originated with an appropriations bill too. Sundry civil expenses, June 28, 1902, which was approved June 28, 1902. And it goes on to say expenses of the United States Court. This is at 32 Stat 419. So this is, let's see, 476, 32 Stat 476. So that's the beginning. Oh, yeah, 475. Okay, so it originated, okay, the first preamble's at 419, and now we're at 475, which is, a whole bunch. It's a big appropriations bill. Some of those are hundreds of pages. Anyways, talks about expenses of the United States Court. For determining the expenses of the Supreme Court, the Circuit Courts, District Courts, the United States, including the District Court of the Territory of Hawaii, the Supreme Court, Court of Appeals of the District of Columbia, the District Court of Alaska and the Indian Territories and Circuit Courts of Appeals and the Court of Private Land Claims. Okay, so those are all territorial courts. That's exactly what those are. Okay, and Hawaii was a territory. It talks about it, but Alaska was a territory too. And Indian Territory is obviously territory. And anyway, so those are all territorial courts. So they go and do this. They do the filing fees and make it applicable to territorial courts. And then they just, and remember the Puerto Rico, where they did the district court, United States District Court. That's territorial, obviously. Anyways, it goes on at 476, the next page. For fees and clerks, $240,000 provided. And then it goes, and I left some stuff out there for simplicity. And the word emoluments shall be understood as including all amounts received in connection with the admission of attorneys to practice in the court and all amounts received for services in naturalization proceedings. Okay, so that's where the filing fees are supposed to be charged, and that is it. Okay, and if you think about it, attorneys practicing in the court attorneys are doing it for business. They're making money off it, so they shouldn't get to do that for nothing. And naturalization proceedings, that's a privilege too. That shouldn't be for nothing. But no amount. Okay, and then whatever. It doesn't matter what the rest of it says. But so the point is the only filing fees that are legitimately supposed to be charged are for admission of attorneys and for naturalization proceedings. An emolument is an advantage, profit, or gain received as a result of one employment or one's holding office. In other words, the clerk gets the money, puts it in his pocket. That's exactly what happens. Filing fees are for attorneys using the courts to make money in naturalization proceedings, which is a privilege. And then District of Columbia, which is 16 Stat 419. Okay, this is actually when they enact to create a government for the District of Columbia in 1871. And it says that be it further enacted, this is section 12, be it further enacted that every bill shall be read at large on 3 different days in each house. No act shall embrace more than one subject, and that shall be expressed in its title. But if any subject shall be embraced in an act which shall not be expressed in the title, such act shall be void, only so much thereof as shall not be expressed in the title. So, in other words, what they're saying is, if we go back here, it says here that it's talking about, this is an appropriations bill, okay? And so, therefore, and then it talks about emoluments, okay, and filing fees, okay? And so, the emoluments, the filing fees are void. Okay, that means absolutely nothing because it's not in the title. It's an appropriations bill, and that's it. Okay, they're appropriating money. They're not spending it. I should say they're spending money. They're not. This is legislation. Okay, and they cannot put legislation in an appropriations bill. Filing fees. Okay, I got that. The traditional distinction, this is actually a Supreme Court case, the traditional distinction between Congress is drawn between legislation and appropriation, the rules of both houses prohibiting legislation from being added to an appropriations bill. And so, again, they cannot put legislation in an appropriations bill. All process of this court issues in the name of the President of the United States. This is Rule 45 of the Supreme Court of the United States. Okay, and so what they're saying here is that there's no separation of powers under the rules of the Supreme Court of the United States. Okay, the Supreme Court is following instructions from the President of the United States. And if you think about it, well, do I cover that here? Maybe not. Anyways, if you think about it, Obama went and he did exactly what he's told. Okay, if you remember this, not Obama, Roberts. Okay. When they went and passed the Obamacare bill, okay, the lower courts, you remember, I don't know if you remember, but I think there was a Fifth Circuit judge there was some case that came up, and this judge was just railing on the Department of Justice and tore a strip off them, and then what happened is Obama got on national television, and he started railing on the courts, and then when this case got to the Supreme Court, they did exactly what they were told to do, okay, and they approved it. Certiorari, this is an original writ issuing out of Court of Chancery, okay? In the Supreme Court rules, it says that you have to go by certiorari. Well, it's a Court of Chancery. They just converted the Supreme Court into a Court of Chancery, okay, which is a court of equity. And it's a court working under the king, okay, or Obama, okay? Again, that's consistent with this Rule 45, okay? And so that's taken from Tomlin's Law Dictionary, 4th edition, Volume 1. And this is actually Downs versus Bidwell. This is a really interesting case. There's some really interesting things it says about it. Anyways, It says, eliminating then from the opinions of this court all expressions unnecessary to the disposition of the particular case and gleaning therefrom the exact point decided in each, the following propositions may be considered as established. Okay? Number one, that the District of Columbia and the territories are not states within the judicial clause of the Constitution and guaranteeing jurisdiction in cases between citizens of different states. So if you're in a territory, as in this case was involving Puerto Rico, but if you're in a territory, if you're in Puerto Rico or any of the territories or the District of Columbia, you do not get an Article 3 court. Okay? That's what they're saying here. The territories are not states within the meaning permits writs of error. Okay? So in other words, if you're in a territory, you cannot do a writ of error. But it goes on, point 3. The District of Columbia and the territories are states, as that word is used in treaties with foreign powers with respect to ownership, disposition, and inheritance of property. That sounds like a trust. So when they go and say in federal statutes that like in Title 28 United States Code, that this applies to the District of Columbia and the states, and then it says and Guam, American Samoa, and Puerto Rico. Well, it's just listing the states. That's exactly what they're doing. If you go into Title 23 United States Code, it says that the states is the 50 states. Okay, so they know how to define it properly. They know exactly what they're doing. These lawyers, these bar members lay awake at night with this stuff. Okay, so point 4, that the territories are not within the clause of the Constitution providing for the creation of a Supreme Court and such inferior courts as Congress may see fit to establish. Okay, well, think about it. So then that's why the Supreme Court, the rules in the Supreme Court are for, it's territorial. It's for the D.C. and the territories. So then if you're not in D.C. or the territories, you're like in Texas, like I am, well, then you don't have to follow the rules. And then it goes on at paragraph 6, that where the Constitution has been once formally extended by Congress to the territories, neither Congress nor the territorial legislature can enact laws inconsistent therewith. And so, therefore, it doesn't matter what they do; their laws are not. They cannot enact laws that are inconsistent with the Constitution. So, in other words, Congress cannot provide de jure courts for the territories, and Congress has to provide de jure courts for the states. Federal courts in the 50 states are not territorial. Under federal statutes, the only Article 3 court is the Supreme Court, because 28 U.S.C. is all for District of Columbia and the territories. No federal statute prior to 1861 involving the courts has been repealed. Courts in the District of Columbia are owned and operated by the Vatican under the bankruptcy. They're staffed by U.S. citizens, which is a Vatican Cestacate Trust, with bar members, which are all foreign agents of the Vatican, which are officers of the court. The only Article 3 courts, the Supreme Court, are not operating under the rules because it was set up by the Constitution. Title 28 United States Code is for the District of Columbia and the territories only. Congress has not set up any Article 3 courts in the states. They could, but they haven't. Barratry. This is interesting. This is taken from Wharton Law Lexicon, 1860 edition. It says a quarrel or contention, the act of a barrator used to be applied to obtaining benefits at Rome. Okay, so it's clearly under Roman civil law. And marine insurance, it is the commission of any fraud. So it's admiralty. Okay. In marine insurance, it's a commission of any fraud upon the owners or insurers of a ship by the crew, captain or crew, as deserting her, sinking her, doing any act which may subject her to arrest, detention, loss, or forfeiture. Okay, so think about it. All of those are admiralty functions. Okay, it is the practice in most countries to insure against barratry. And so think about it. Arrest, detention especially is admiralty. Okay. The National Bar Association was set up in 1878. Bar card union members have infiltrated the government and every major corporation in every country. Bar card union members have infiltrated every governmental entity at every level, every city, every county, every state, every court, everywhere in America. 2/3 of the lawyers in the world are in America. Albert Pike, a prominent Luciferian and Masonic leader, a Confederate general, wrote Morals and Dogma, predicted 3 world wars, talked about consolidating the entire planet, people, places, and things into the hands of one entity, which is sometimes referred to as the Antichrist, or the god of Freemasonry and the Illuminati, Lucifer and Satan. Okay, and that's found at page 321, Morals and Dogma. We are now building up to World War III, as predicted by Albert Pike. It's just going right along like clockwork. The once honorable, this is from a bar member who has now passed away, by the way. The once honorable profession of law now fully function as a bottom line business driven by greed and the pursuit of power and wealth, even shaping the laws of the United States outside the elected Congress and state legislatures. This is actually, I got several slides here talking as Justice John F. Malloy, Arizona Court of Appeals, in his book, The Fraternity, Lawyers and Judges in Collusion. This case law system is a constitutional nightmare because it continuously modifies constitutional intent. For lawyers, however, it creates endless business opportunities that, because case law is technically complicated and requires a lawyer's expertise to guide and move you through the system, the judicial system may begin with enacted laws, but the variations that result from a judge's application of case law all too often change the ultimate meaning. When a lawyer puts on the robe and takes the bench, he or she is called a judge, but in reality, when judges look down from the bench, they are lawyers looking upon fellow members of their fraternity. That's exactly what's going on. In any other area of free enterprise system, this would be seen as a conflict of interest. When a lawyer takes an oath as a judge, it merely enhances the ruling class of lawyers and judges. First of all, in Maricopa County and Pima County, judges are not elected but nominated by committees of lawyers, along with certain concerned citizens. How can they be expected not to be beholden to those who elevated them to the bench? Today, the skill and gamemanship of lawyers, and not the truth, often determine the outcome of a case. As we lawyers love it, all the tools are there to obscure and confound. The system's process of discovery and the exclusionary rule often work to keep vital information off limits to jurors and makes cases so convoluted and complex that only lawyers and judges understand them. The net effect has been to increase our need for lawyers, create more work for them, clog the courts, and ensure that most cases never go to trial and are instead plea bargained and compromised. All the while, the clock is ticking and the monster being fed. The sullying of American law has resulted in a fountain of money for law professionals, while common people who are increasingly affected by lawyer-driven changes and an expensive self-serving bureaucracy are left confused and ill-served. Today, it is estimated that 70% of low to middle-income citizens can no longer afford the cost of justice in America. What would our founding fathers think? This devolution of lawmaking by the judiciary has been subtle, taking place incrementally over decades, but today it's ingrained in our legal system and few even question it. But the result is clear. Individuals can no longer practice in the legal system. It has become too complex and too expensive, all the while feeding our dependency on lawyers. By complicating the law, lawyers have achieved the ultimate job security. Gone are the days when American courts function to serve justice simply and swiftly. It is estimated that 95 million legal actions now pass through the courts annually. And the time and expense for a plaintiff or a defendant in our legal system can be absolutely overwhelming. Surely it's time to question what has happened to our justice system and to wonder if it's possible to return to a system that truly does protect us from wrongs. They're a bunch of Satanists, okay, boys and girls, that's exactly what they are. I had someone who is a legislator contact me recently about writing a right to travel law in the state, not Texas. And they told me they had to do a legislative service request to get a bunch of bar members to write a bill for them to present it to the legislature. And this is a member of the House of Representatives of a state. So these bar members are responsible for every piece of legislation that is presented in any legislature anywhere. Bar members are responsible for every code, rule, or regulation anywhere. Bar members control and manage every court everywhere except truly common law courts. Bar members have infiltrated every corporation to the highest levels, and they either hold key positions like chief counsel or they influence those who do hold the key positions. Is there any wonder why Christ had such complete and utter contempt for the attorneys of his day? What can we do? We can educate ourselves so we know when our rights are being violated. We can work with our friends and neighbors to reestablish our common law juries and our common law jury courts. Okay, that's where the answer is. Okay, it's not with these Baal priests, these Satanists. We can educate our public servants because many of them do not know any more than we do. We can educate other people by circulating this video in any other way possible. We can work with our friends and neighbors to get the United Nations out of America and Canada and anywhere that wants to be free. This is all coming from the United Nations. These bar members are all coming from the United Nations and their Vatican handlers. We can educate ourselves about what a common law jury is and what the law of the land is, or the law of the land. Common law is the law of the land. We can demand a common law jury of our peers. Judgment Day is coming for these bar member thieves, and I'm looking forward to it. I'm looking forward to seeing some of them do the little dance they do at the end of a common law rope. There are common law courts springing up all over, and these thieves are going to be brought to some real justice. And I'm glad it's not up to me. Okay, I would never, ever want to take the law into my own hands. You can never take the law into your own hands because it makes us worse than they are. Okay, we need to walk the high road. This is Revelations 22-3. And he laid hold on the dragon, that old serpent, which is the devil and Satan, and bound him 1,000 years and cast him into the bottomless pit and shut him up and set a seal on him that he should deceive the nations no more till 1,000 years be fulfilled. By which, and this is 1 Peter 3:19, by which he went and preached to the spirits in prison, and Isaiah 24:21-22. And it shall come to pass in that day that the Lord shall punish the host of the high ones that are on high, and the kings of the earth upon the earth. Gee, that sounds like bar members. And they shall be gathered together as prisoners are gathered to the pit, and they shall be shut up in prison, and after many days shall they be visited. Copies of these documents can be found in my private group at Yahoo called Administrating Your Public Servants. I have YouTube videos that are videos of private information shares that show these and other court citations. Send me an email for copies of documents to engineerwin@gmail.com. I appreciate you take the time to watch this.